Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Bring the jury.
Hello, couch potatoes. Guess what? This is our first Couch Court with Llama only show on the new channel. So that's very exciting. We've been, doing dual streams, but this one with True Crime and Wine Time, but this one is just on Couch Court with Llama. It's a very exciting moment, isn't it? I'm excited about it.
I know.
And today we're going to be talking about the O'Keefe versus Karen Reed civil trial, which makes Couch Court with Llama full circle because the very first case I covered was Karen Reed's retrial last year. And so here we are, first show only on this channel. We're back with Karen again because it is the story that just doesn't go away. Well, for good reasons. There's still so much more to be had. There's 4 civil trials going on right now. We have O'Keefe v. Karen Reed that we're going to be covering first. We're going to catch you guys all up. We're not going to sit here and read every single document. I've already done that for you, and trust me, you will thank me. They are not as fun. Some are, and we're going to read the fun ones. We are going to read the fun, spicy ones. But a lot of them I just summarized for you guys. So that way we could get caught up with that because there is a hearing next Thursday, I believe, for the O'Keefe v. Karen Reed. So we were trying to catch up for that. And then there is also it goes O'Keefe wrongful death. Then the Karen Reed sues everybody, which is now turned into a civil case. Basically, Karen is suing the people at the house, the Alberts and the Higgins and the McCabe's, but that has now been sent to federal court. So unfortunately, we probably won't see much out of there. However, there's plenty of documents to go through that gives us a good idea of what's going on there. So we'll cover that one. Then there's the other trial, which is so O'Keefe started in 2024. The next one started in 2025. Then just this June, 2 more dropped. One, Karen suing Massachusetts State Police and the Canton Police Department. And then Ham v. Karen Reed, which is Higgins, Albert, and McCabe suing Karen Reed and Turtle Boy for defamation. So there are quite a few.
So much happening.
But don't worry.
That is a lot.
I spent a lot of time organizing all of the documents, going through them to make sure that we hit all the important points, watch the right hearings to get us caught up. But before we go further into O'Keefe v. Karen Reed, let's say hello to 80s Music Man. Hi, hope you're doing well today, 80s. Happy to see you here. Mary, hello. Thank you for being with us. Lady in Gray, good morning. Good morning. And Pam, good morning to you. Hope you're doing well. Lady says there are a lot of suits involved in this chaos. There is, and they're all happening at the same time, but also not at the same time. So hello, Angie. Good morning to you. Now, I actually watched this first hearing that we will be watching later today back last September when it aired. And I was like, oh, we're going to keep up on it. But I've been doing a lot of other stuff since then. And then when I looked at the docket, also the tickler, I can't take it seriously.
Gucci.
I know it's so unserious. It's basically like the calendar of events when things need to be due by, because civil courts, I guess, are a lot more like this is due here, which I appreciate. I was like, oh, now are they good at doing all the things on time? Nope, not at all. And next week, when we get into more of this trial, we'll know why. But on there, it does say that they're having their last pretrial conference in January with a judgment by the end of August 2027 of next year. Now, can those dates be moved? I don't really know. I don't think so. But I don't know that to be entirely true. I'm not super good with civil cases in different courts because they're all very confusing, to be quite honest. Hi, Deanna. I hope you're doing well. Thanks for joining
Hi.
us today. Good morning. But if it stays true to what the tickler says, then I think we're expecting a possible trial for the O'Keefe v. Karen Reed and the bars by spring, probably April, May, if it's going to be a big one. I don't know. As I said, we have to cover all of 24, 25, and 26 to get caught up now. But according to the docket, that is what the dates they have in there as of right now. So I was like, oh, well, then we're really going to need to start catching up now because things are going to go really, really fast. And they've already started going really fast based on my spreadsheets. So that way we don't get too far behind with this one possibly going to trial next year. We're like, all right, let's get into some more Karen Reed because it's been a while. It's been a while. If you haven't watched the previous Carol Reed criminal trials, they were, oh, what a doozy those were. It can't you can't even overstate how interesting that trial was for numerous reasons, both from the state, which made some very interesting choices of who they put on the stand as experts and whatnot. It was a disaster. It was absolutely, I've never seen anything like it. And then you had Karen Reed's defense team, who top notch. Like, you want to see some good lawyering? Let me tell you what, her defense team was amazing. Because I only watched the retrial. You have watched both trials. Well, at this point, I've now watched a lot of the first trial, but I didn't watch it when it was live and happening. But hi, Rob. Hope you're doing well today. Hey. Well, anyway, Karen Reed was acquitted, found not guilty in her criminal retrial. So, if you haven't seen it, I recommend going back watching it. It is, especially if you never watched a trial before, the bar will be very high from you going on, and I'm going to let you know most trials aren't that spicy, but there is a lot to learn with it. So if you are interested in rewatching it or you never watched it, you can go to the trial channel. She has it all broken down, all the stuff, no sidebars, no breaks, all the stuff you can't hear. She goes ahead and takes that out to make it a lot quicker for you to go through. Because I think, oh gosh, when I did all the math for our couch court 1 year anniversary, I wanna say our coverage hours for Karen Reed was like 232 hours just for her trial. So it can be a lot to go through, but I recommend going to her channel. So
Yep. That was the first time I ever accompanied you on this stream.
that's right. That's right. Because y'all were like, Llama, you need to watch it. You need to. You're gonna go crazy. And they were right. You'll never know if it was snowing. It was snowing enough to track a cat. Gee. Oh gosh, Massachusetts hurts my brain so much. I don't understand what's going on.
Yeah.
But so let's go ahead and get into my notes about the O'Keefe v. Karen Reed case. Like I said, there is a hearing that we are going to watch today. It was the first shown televised hearing. They had previous ones, but they were not for the public. And we'll get to watch that today. But before we get that, I have to go over what's happened between then and then. All right. So let me scroll here through all of my notes. So the plaintiffs in this case are the O'Keefe family. We have John O'Keefe's estate, right? The victim, Officer John O'Keefe, Paul O'Keefe, John's brother, who's also acting in behalf of John O'Keefe's estate. Then we have John O'Keefe II, which is their dad, Margaret O'Keefe, the mother, and then Kaylee, the niece of John and Paul. Now, if you don't know the story of John O'Keefe and his niece, his sister and husband, her husband died very close in time to one another, orphaning both of their children. And John O'Keefe took them in and raised them for several years. I mean, how at least 8, 10 years maybe. He took on the role of, adopting them treating the man as his own. So that's why if you're like a niece, why, if you don't know the story, they were basically his children as well. Because listen, I haven't heard much about John being a bad guy in any way, you know? I mean, not in a sense that you're like, oh, this guy. No, I've only heard actually really nice things about him. Um, and to even do that, to take care of your deceased family's children is really commendable. To be like a single dad most of the time. And he took that role very seriously. And I very much have a lot of respect for that because that's not easy at all. So those are the plaintiffs of this case, right? I should have made visuals, but I didn't have time. Sorry, guys. Maybe for the other ones. Right. You've never heard any either, Rob. Yeah. I mean, yes, people don't really like to talk ill of the dead, of course. But I mean, when you're trying to win something, you'd think there would be something, but not really. Nothing alarming anyway. Anyway, so the plaintiffs, his family, is suing Karen Reed for wrongful death and intentional affliction of emotional distress. All right. And they're also suing both of the bars that they were at that night, CF McCarthy's and the Waterfall Bar and Grill, which are talked about a lot in the trial. A lot. They're both the bars they went to before going to 34 Fairview. So those are the defendants in this case. That's it. All right. It's O'Keefe versus defendants. But you will hear that there's a lot of other interested parties. In this case, the list is long. It's like everybody else. But you'll see why they're in this as well. But they're not actually part of the lawsuits. They're mostly like witnesses and things like that. Now, all of those people, though, are going to be in other lawsuits. So they start. Oh, hold on. Lady and Grace says everything said he did great things for the children. He was so proud when his niece got into an elite private school, which his mother pulled her out of after he died. Yeah, he was a very, it's hard to be that role. I give him a lot of credit for that and be a police officer. Man. All right. So they start this case against Karen on August 26, 2024, which on the timeline, she has just finished her first criminal trial, which ended up a hung jury. It was a mistrial because the jury could not decide. And they ended up bringing the charges again and charging Karen again because they're a bunch of idiots over there. Honestly, it was such a waste of money. The people should be absolutely fucking pissed about how much money they spent in the retrial on garbage. But anyway, that's a story for a different time. Go watch your trial coverage over it on True Crime and Wine Time. You'll see. Anyway, so the O'Keefe family, that's just what I'm going to refer to them as, the plaintiffs or plaintiffs, right? They filed their complaint with the courts for a wrongful death lawsuit against Karen, CF McCarthy's, and the Waterfall Bar and Grill. So this is filed 2 months after Karen's first criminal trial that I said ended in a mistrial. And the first thing they do is they file their civil complaint, right? So this is what they're alleging happened and why they're bringing this lawsuit. Again, this is between the two trials. And they weren't the same two trials, as I learned. There's a lot of new stuff in the second trial that was not brought up in the first one. Hi, Phil. Good morning. Hope you're doing well today. Happy to see you here.
The defense's strategy was completely different the second time around. So was the prosecution.
Yeah. It sure was, wasn't it? Oh, man. We'll never forget Aperture. So in the civil complaint, they have alleged facts. All right. This is what the O'Keefes say. They said there's a sequence of over-serving alcohol followed by reckless and intentional actions. All right. They go on to say that the relationship, this is their theory, that the relationship between Karen and O'Keefe was deteriorating by Karen's alleged jealousy and delusions of unfaithfulness, which they tried to use in the court. It didn't do much for me, like at all. It seems, couples argue and stuff, but okay. They said that CF McCarthy's served Karen 7 alcoholic beverages between 8:58 p.m. and 10:29 p.m. on January 28th, 2022. I also want to note, though, While Karen was found not guilty of all of the murder charges, she was found guilty of a DUI or an OMVI, whatever they call it in Massachusetts. But for driving drunk, she was found guilty of that, and that was it. Or they went about their day. They said that Karen showed signs of intoxication while at CF McCarthy's, but was still allowed to leave carrying her drink at 10:40. Karen and O'Keefe entered Waterfall at 10:54 p.m., where she was served a shot and a mixed drink despite showing signs of intoxication. Reed then drove O'Keefe to 34 Fairview, the infamous 34 Fairview, in Canton, Massachusetts, while under the influence of alcohol, possessing a blood alcohol content estimated between 13% or 0.13% and 0.29%. Which again, in the second trial, was rather questionable how they came to that conclusion. So, what was it? They were doing weird lab math, right, Buffy? I don't
Yeah, they were like doing like a
guesstimate
now I
math.
can't remember the name of it, but it was like they were going backwards. They were like
Yeah,
taking the time at the hospital and then like retrofitting it to what she would have been at a certain time, which I
yeah,
mean, there's so many variables on
it was.
that it makes
It
that kind
wasn't
of
great.
math to
It,
me questionable. So
I don't believe it was the lady who testified to that got her the DUI charge. It was Karen saying how drunk she was on, or that she had been drinking, not how drunk she was, that she had been drinking in her interviews that she did publicly.
yeah,
That's what got Karen.
that they played during court. Yeah,
Yeah,
I
the
think that's
clips,
what got it.
because she
If
she
she
said how
hadn't
many she
agreed,
had. Mhm.
if she hadn't, they may have not come to that, or they may have just said, "Hey, look, we got to charge her with something, so it doesn't sound like we were just
Mhm.
giving her a pass." Who knows? We don't know what juries do.
Yeah, because when they played the clip from the documentary, I was like, "Well, girl, guilty on that one. You just,
I mean, I'll
you know."
take a DUI charge over like murder. Like,
Absolutely, absolutely, and she was drinking, I mean, so yeah, fair, absolutely fair. Um, so then they go on to say that they believe that Karen hit O'Keefe with her SUV, knocked him to the ground, and left him in an impending blizzard. That didn't happen for quite a few more hours, like 7 more hours or something, knowing it would likely result in serious injury or death, that Karen fabricated a false narrative and conspiracy to avoid accountability, which caused the family aggravated emotional distress, and that Karen woke up O'Keefe's traumatized 14-year-old niece, Kaylee, at 4:30 a.m. to frantically discuss hitting him, inflicting further emotional pain. Now, we didn't get to see Kaylee's testimony. She was a minor at the time. I don't think she is now, but that we did not watch that. There was no nothing regarding her, right? There wasn't even audio for her, if I recall. Sometimes
no,
they do that, but I don't think they did here.
no, there is no audio. You had to get the play-by-play on X.
That's right. So that's their complaints against Karen. Now, their claims against the bar is that they're going with the dram shop liability laws, and dram shop laws basically hold businesses liable of their of they hold business liable if they serve alcohol to an intoxicated person who subsequently causes harm. Right? Over serving, as many of us know. It's not the first time. I'm sure many of you have heard of cases like this where there is this responsibility on the establishment to cut people off instead of just feeding them alcohol and whatnot. You can lose your license. You can be included in a lawsuit like here. Whether or not that's the case here, I don't know. We'll have to find out. But
Mhm.
that is what they're claiming against the bars by suing both of them for wrongful death, for acting with gross negligence and utter forgetfulness of their legal duty by continuously serving a visibly intoxicated Karen Reed. I'm going to say this because we watched the bar
I
video.
was I was that was where I was going to interject my opinion, but I was
Sure, go
like
ahead
waiting
with
for the
yours.
time. How are you like I know I took the test. I had the bar card for my state. Like
Hmm.
because when I ran a when I was a manager, we had a bar inside, so we had to have our
Right.
bar stuff. Anyway, so if somebody is not visibly showing signs of intoxication or what you would determine, like it's completely subjective, right? There
It
are
is.
people that can be extremely intoxicated but manage their alcohol very well.
Mhm.
And then there's others that are tripping over their own like feet.
After
So,
2
I mean,
drinks or something, yeah.
right.
Very subjective. I don't
And
know
I didn't
how
see that in the
I
videos
didn't either.
that we saw.
I didn't either.
She didn't appear that way to me.
It's no different than anybody else that was at the bar. As a matter of fact, some of the other people seemed much more intoxicated, if you ask me.
Right. Right.
In comparison, I didn't think she came across as I don't see how the waterfall would have known that either. The second bar that they went to where she had
Now,
like 1 drink, but whatever.
we didn't actually get like audio with those videos, and
Mm,
maybe there was some speech or something that should have been an indicator because we only got the video with no sound. But I wouldn't have, just going off of that without
mm.
hearing, I wouldn't have thought that, which I feel bad for the bars being caught up in it because that just kind of seems like a
Yeah,
reach.
particularly the waterfall. Again, she had 1 shot and a drink. That's completely normal for a bar based on the videos they played in her criminal trial, which I imagine they're going to use in this one. I don't know about that one. Now, see if McCarthy's again, we saw those videos. I didn't think much of that either, but she did admit to having 7 drinks there. So we'll see. But anyway, it's not surprising though to see this lawsuit against the bars. That's
Yeah, I know.
pretty common. So then Margaret, John, and Paul, the family, are individually also suing both bars for negligent infliction of emotional distress. And the family claims the bars failed to hire competent staff, failed to provide safety training, and ignored the obvious risk of serving someone who was already drunk. Ugh, I don't know about that. I don't know. Robert said, Robert, didn't mean to full first name you. It's in your handle, but still, I never called you that before.
I'll
Rob says,
say, are you his mother?
I guess so. I guess so. Rob says the bartender is the best to determine if someone is drunk, as they're the only ones who should be sober. And that's a hard thing to be responsible for because it's hard to tell sometimes. Absolutely. Absolutely it is. I worked in like, yeah, if somebody's like passed out in the bar yeah, you can tell when someone's super intoxicated, but I didn't see that though in these videos from the trial. But we'll see. There probably is going to be new evidence in these trials, maybe. Lady in Gray says the jury was confused if the DUI was for the night after bar hopping or in the AM when he was found. They sent a note to the judge asking for clarification, which was denied. And the indictment didn't say, oh, yeah, that's a good point. But I mean, again, she did say it in the interview. So there's that. It doesn't really. It doesn't really matter. But you are right. They did send a note. I forgot. Hello, Negla. Gonna be replay crew. I love that. And thank you so much for stopping by so we can get those live views. Because
You're
we
so
need the
sweet.
views, the watch hours, and the subs. So if you haven't yet, please like this, subscribe, hit the notification bell if you can. That'd be great to help this little channel out here. So then again, they have their claims against Karen, um, some more targeting her about her actions behind the wheel, that she breached her duty of care with O'Keefe by driving drunk, acting recklessly, and hitting him with her vehicle. Um, they said they have that she was doing infliction of emotional distress on the family by causing his death and by outrageously creating a false narrative to deflect blame. They're very hell bent on this. And then, of
Wow.
course, there's also a count for distress to a minor regarding Kaylee and waking her up when, you know, Karen was like, where's John? Where's John? Sort of thing. Now, some of you might be like, well, wait a second. If she was found not guilty and acquitted of charges, why is there a civil suit? I mean, she obviously didn't hit, that's what they determined, right? Well, it's important to know, if in case you don't know, that civil lawsuits have a much, much lower burden of proof called the preponderance of the evidence. So, like, 50, if you think 51% or more this was her doing, then boom, guilty. Unlike in criminal court, where it's beyond a reasonable doubt. It's a very high bar. Like you got to be sure, right? So that's why while their theory in one court didn't work, it could actually work in a civil suit. For example, the most popular example is the O.J. Simpson trial. He was acquitted of charges and then found guilty of the death of Nicole um, in the civil suit in order to pay millions and millions of dollars to her family. So it can happen. I get it's confusing, and I do agree in that, but there is reasons, and that's just how it goes. So remember, the jury is going to be asked in this is it more likely than not? That's it. That's all the jury has. Is it more likely than not that Karen was reckless? Is it more likely than not that the bar did overserve her, causing this chain reaction of events? Right? It's not the same kind of high bar. Hi, Say Cheese. Good morning. First, you're getting into this case. I do know the brother of one of the Reed's criminal defense attorneys. I just didn't have time to follow when it was being heard. Girl, as as I know, for you, rock star defense attorneys the whole time, just unbelievable lawyering done. Robert Alessi, amazing. I mean, they're all amazing, but like, oh, it's so good. I mean, it's one
It
of
was.
those like, you are it's a very interesting trial to watch. I highly recommend it. The trial channel has it all broken down without the sidebars that we can't hear and breaks and stuff. And it is worth it. It is worth a watch. I promise. Masterclass of defense lawyering, in my opinion, as a layperson. But no, really, it's wow. Um, I know what? So shocking. So that's the difference between a civil lawsuit and a criminal trial. So that's why they can bring this, even though she has been acquitted of those charges. So is it a little bit of a bigger hurdle? Yeah, but also no, because the bar is very low here. So now, while this was filed, as I said, Karen is in between her first trial and her retrial. Um, and she was found guilty of DUI. So let's compare the allegations and the 2025 trial outcome and how they may impact this civil suit now that we've went over what the differences are. All right. So the allegation that Karen was heavily intoxicated with a blood alcohol count far exceeding the legal limit. So she was found guilty of that, of operating under the influence. That's what the charge was. And what this could mean is that while the criminal jury agreed with the plaintiff's complaint and what they're bringing to the table here, um, that Reed was driving drunk that night, this conviction heavily supports the family's dram shop claims against the bars. It is going to be a little, it's going to be a difficult hill to climb, I think. But again, it's mostly subjective. So I think there's a fair argument on both sides here regarding those. Now, for the wrongful death that Karen recklessly or intentionally hit O'Keefe with her SUV and left him to die. So, again, she was found not guilty of second-degree murder and manslaughter. So, the criminal jury felt there was reasonable doubt that her vehicle caused his fatal injuries. However, the civil suit can still attempt to prove she caused his death using this lower standard of proof because it's not beyond a reasonable doubt. It's, you know, what did I say? More likely than not.
Yeah. Is it more likely than
So that could be problematic. Allegation, fleeing. All right. They're saying Karen hit him, fled the scene, and returned home. She was found not guilty again of leaving the scene of an accident. What this could mean is that the defense's argument that she didn't hit him logically meant the jury could not convict her of fleeing the scene of an accident she allegedly didn't cause. Again, that makes sense, right? These are all very good arguments for Karen Reed's side as well. Um, if one of my favorite trials, both, yeah, it was her female attorney. Her brother was a prosecutor. Nice kid. He left the
It was
DA's office
Elizabeth
to go.
Little.
Yeah, Elizabeth Little. She didn't get
Oh,
to say much in the trial, unfortunately. But
brother's a
she does do a
prosecutor.
lot of arguing as well. She did a few of those, but again, a huge asset to the team. My God, she did so much work for them as well. And she's on the civil suit as well, by the way.
Elizabeth
Um,
Little's on top of everything.
yeah, she's the real MVP, and the others will say as much too. They speak very highly of her. What was his blood alcohol level? I don't think they said. That's a good question. I don't think that it was brought up, but I am not entirely. I can't remember. It was a 6-week trial, so.
And it was like
Hi,
2 years
Jupiter.
ago.
Hope you're doing
I
well.
don't know if I remember. I think they did bring it up.
Did they?
Yeah.
I don't know.
But do I remember the number? No, I would be lying to you if I said any number because I
Yeah,
don't know.
I
But
don't
I
remember there
want to
being.
say it was brought up.
Could be.
That's
Who knows which
making
trial it
sense.
was? Maybe it was in the first one and not the second one. I don't know.
Yeah.
I don't recall. I think they would have probably been able to get a good one from him, a good reading, because he
Well,
was
at the
outside
time
in
of
the
death,
cold
yeah, it would, yeah.
too, right? So it's a good question. I don't recall. If you know, please definitely let us know. So then there are other allegation, the false narrative, the secret conspiracy. That Karen has outrageously fabricated a conspiracy to frustrate justice. Those are their words. So the defense strategy in the criminal trial succeeded because this was their defense. It was that the police was corrupt, the investigation was corrupt, the people inside that house that night were corrupt and conspired. Something had happened to John in the house, and they decided to put the blame on Karen, and they were responsible for everything. And defense had a fairly good argument for that. Um, oh yeah, it's definitely, definitely say cheese, definitely. Um, Now, what this could mean, though, is that the false narrative the family refers to, excuse me, is a successful argument that O'Keefe was beaten inside 34 Fairview home, and they all plotted to frame Karen Reed for this. I know it sounds fantastical, but I assure you, it sounds just as likely, if not more so. Now, while the family views this as an outrageous lie that has caused them emotional distress, it was a legally viable defense strategy that resulted in her acquittal on the most serious of charges. And they're going to this, well, they are. All the civil trials are about this conspiracy. Every single one is about that. So it's going to be brought up a lot. And you're going to be like, if you haven't watched it, you're going to be like, wait, what? What do you mean? Oh, these people are sketchy AF. Mind blowing, really. And they're all cops too. So there's that of some kind. They're in law enforcement of some kind, different levels. Anyway, so that's their complaint, the O'Keefe's complaint here that they filed for Karen and the 2 bars. So then September 13th, 2024, Karen Reed is then represented by William Kevel, Marissa Peradini, and Christopher George from the law office of Mellick and Porter. Now, I am going to let you know who all the lawyers are because there's a bazillion. There's a bazillion lawyers in all of the cases. I'm not like everyone has like 15 lawyers. It's wild. But that's who represents her first, okay? Because we have, these are not her criminal attorneys at the time. These are civil attorneys. Because her criminal attorneys are busy preparing for a stupid ass retrial. That being Yannetti, Jackson, and then they bring on Alessi for the second trial, right? He was not in the first one. Was there somebody else in the first one?
No,
Or was it just Yannetti and Jackson and
it
Little?
was
I
just
mean,
Yannetti and
Elizabeth
Jackson
was
and
part of it
Little.
as well. I don't want to push her off to the side because she is very important. So it's just those 3. And then,
Alessi just got brought on at the second trial.
right. Okay. So then September 20th, 2024, CF McCarthy's is represented by Tamara Halstag, Lincoln Rose, which is a very cool name, by the way, and Kevin Burgeon. So you already got, 3 lawyers on each for Karen, for CF McCarthy's. So then October 2nd, 2024, Karen asked that there be a stay for the case until the conclusion of her retrial. Meaning, can we just pause this until this retrial is over? Pretty fair request, I think, but don't worry, we're going to get into it. Their argument is that with the civil case at the same time as the criminal one, it will adversely affect Miss Reed's Fifth Amendment rights and her ability to vigorously defend herself from criminal prosecution. And so she's requesting the judge sign a motion for stay, which again, yeah, I mean, because she's found not guilty, or I'm sorry, mistrial was like July 1st of 2024. We're at October 2nd, 2024. Her next retrial is supposed to be January of
Mhm.
2025. We know it gets
Yeah.
pushed to April of 2025, but like, yeah, like it's
I
not like
couldn't
it's a few
imagine
years out.
fighting on 2 fronts.
Right, right. Oh yeah, that's right. They didn't have Karen's blood alcohol. They did an I can't say that word, test based on subjective factors. Yeah, oh my
Right.
God. Also, say cheese. I need you to watch it too because they're expert witnesses. I promise you have never seen anything like it. I mean, maybe you have in your course of work, but like eh, unbelievable. Unbelievable what the state does with the witnesses and the experts that they bring in. It's wild. Oh, and you
Yeah.
want to know how they collected evidence, say cheese? No joke, because it was snowing. All right. They collected evidence in red Solo cups and put them in a shop and go paper bag. That's how they collected the evidence from the scene.
Wait,
Uh-huh.
doesn't everybody do that? I thought that was
Oh,
standard operating procedure.
that's right. That is what they say.
And I did
And by
see
the way,
that on an episode of CSI before.
those Solo
It was
cups came from
CSI Massachusetts.
somebody else's house. All right. You want to see corruption? Holy shit. And they put it all on display. On display, on display. Anyway, I'm not going to go on my housewife song, but it's wild and very brazen. Very brazen. Um, Little does seem to have an encyclopedia. She is on fire with everything. She's amazing.
She's the spreadsheets person. She knows where everything's at. I guarantee you. She's like
Absolutely.
I got that.
Got it. I know. I want Karen to live and breathe in life, but unfortunately, that's never going to happen in pursuit of justice. So, unfortunately, Llama, this because they were drinking at a house party, all they had were the red cups. Real professional, I know. No. They were the neighbors' red cups from across the house, weren't they?
Yeah, it wasn't even from that house because they
It wasn't
never
from the
actually went
Alvarez
into the house.
They went to a different person's house and was like, "Do you have something I can collect snow in?" And then that was it. And they just let him sit in their car. Do I have to watch the original? No, just watch the second one, babe. It's fine. Just watch the retrial.
I mean, if you really want to know all the things, yeah. I mean, I know having watched the first trial
That's
gives
true.
you a different perspective on the second trial because you know a lot more that wasn't brought into this second trial.
And they don't have all the witnesses in the second trial.
All of
None
the
of them
witnesses
testified
are not
except for Jen.
They brought in everybody in the first trial, like everybody. In the second trial, the witness list was significantly narrowed down.
Yeah. It's wild, say. It's wild.
I mean, no, I guess you don't have to, but like if you want to know all the things, yeah, you do. Because there's a lot left out. Because even I made you go back and watch old testimony.
Yeah, I would say go back. Again, the trial channel has it broken down by who does what. I ended up on the days they didn't have court, we went back and listened to like the testimony of the people that were in the house that night because they weren't in the second trial.
I would say the cops and the house defendants for sure.
Yeah, because not all of them are in the second trial for a good reason, for a very good reason.
Yeah, I would definitely say the cop police testimony Proctor's testimony because he's a significant player in everything.
Yes,
And
that's true.
and
Yeah, so you're
definitely
gonna
the
need to
House
do both.
defendants.
Don't worry, it's worth it. It's worth it, I promise. That was, even though it was a 6-week trial, it was every day was something
See, and
wild.
you're
Every
not going to get
second of every
Higgins
day.
either. And he's a significant player because you're going to see video
Yeah.
that was played of him in and out, but he doesn't even get introduced in the second trial. He didn't testify.
Yeah, that's true. Proctor didn't either. Also, for very good reason. You'll
Yeah.
see. Oh my gosh, I'm so excited for you. Because listen, my friends kept telling me, trying to get me to watch it, and I was like, no, I don't want to. And then I watched this. Then they got me for the second one, and now I'm like, oh my god, this is real life. I can't believe they were that blatantly corrupt in public, constantly.
Yeah, this
Unbelievable.
trial was right up your alley from on the first one, but we just couldn't convince her to do it. And now she's like, what?
What is happening? What is happening? It definitely earns the hype that people give it. I will definitely say that. You'll thoroughly enjoy it, say. All right, so Karen asked for the motion to stay. All seems reasonable. She has a criminal trial in just apparently 2-3 months at this point in the timeline. But the plaintiffs are not happy about this stay, and they oppose it. And I am going to read their opposition to it because it is spicy. Because everybody hates Karen, by the way.
Okay,
Just let you know.
so this is the opposition to her for the stay. This is
Yes,
the
by the
okay.
plaintiffs. Yes. So this
This
is the
is
family's opposition, and they're mad, and they say not so great things.
Wait a minute.
I
So
get it.
they're mad that she wants a break so she can go through the criminal trial.
Yes. Yes.
Wow. Okay.
So I hope you're ready for the large amounts of snark in this one, because I'll tell you what, I was
Okay.
like, oh, we're so reading this, because we're not going to be reading too many of the documents, like I said. But if it was spicy, I was like, oh, we're going to read it. Okay. So that way everybody can get the vibe, the energy that was in the air at the time.
And
all
the
right.
timeline. I need the timeline. This is
Right.
October. This is filed October 2nd, 2024. Okay.
Correct. Yes. So they say in the instant motion, civil defendant Karen Reed seeks to stay civil discovery largely because Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place. And because the privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is going on. Additionally, Ms. Reed claims the only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. See her motion to read, which I already read to you. It was a whole 2 pages, 3 pages. And they go on to say, in certain cases, we may agree. Here, however, Ms. Reed consistently and voluntarily disregards her Fifth Amendment privilege as she attempts to craft her own narrative and poison the jury pool in both the criminal and civil cases. I told you. They're like, no. Karen
So
Reed,
basically, they're like, she's doing all these interviews.
Yeah.
And so if she doesn't care about that, then she should not have to worry about a deposition. where
government.
She
Yeah.
can't control the questions that are being
Well, I guess
asked
it's not
her.
the
Okay, that
government.
makes sense.
It's not the government in this case, is it? Because it's civil, but still in a criminal trial, right? Like, exactly. And that's what they're about
But
to
she
say.
still gets to pick what she answers when it comes to the interview. She can't really control what
Right.
she answers in a deposition.
She's not under oath, risking penalty of perjury or jail or something like, I don't, okay. So they go on to say Karen Reed has spoken publicly in interviews that we know of with NBC's Dateline, ABC's Nightline, ABC's 2020, Vanity Fair, NBC's Today, and yet to be disclosed Netflix documentary. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self incrimination and more about controlling the narrative to suit her interests. Well, yeah, okay. But also, that's not court. Everybody else gets to go say things. I know. Right? The court, in its discretion, certainly should not reward her ulterior motive of self-promotion. That pesky, evil Karen Reed. The right not to self-incriminate does not come with the right of self-promotion. And then they go into some legal standard. It doesn't really matter. Nevertheless, oh wait, no, that's all right. Going summary of facts and procedures. All right, yeah, that doesn't matter. It really doesn't. A simplified summary of facts introduced at the criminal trial and procedural history is as follows. Oh, she's going to have 9 drinks. The trial ended in a mistrial. Okay, so here's their argument. This is where it gets spicy again. The estate has great reason to pursue civil justice against Karen Reed for wrongful death, whereas 8 of 12 jurors, uninfluenced by the media circus, when tasked with resolving the facts under the high standard of proof, beyond a reasonable doubt, believed that Reed was guilty of OUI manslaughter. This is regarding the first case. Remember that. Our civil case only requires 5 of 6 of the jurors when tasked with resolving the facts under the lesser standard of proof, more probable than not, to hold Reed liable. To hold Reed liable, any 2 of those criminal jurors who maintained no there could easily have been persuaded to change to a yes vote in the civil case here. I don't understand this argument because they're all going to be different people and they're different burdens and it's not the same, but okay. I mean, what do I know? Let's see. It is not difficult to imagine 2 of the no jurors being persuaded by the deliberating jury that Reed's drunk driving more likely than not caused O'Keefe's wrongful death. They're like, yeah, those people that disagreed in the mistrial, thought she was not guilty, they could probably vote guilty in this civil trial. But if they didn't think she hit him, then how would they even come to this conclusion?
It wouldn't even matter. Can you use this argument wouldn't. She was found not guilty in the second trial. Everybody's different. Like every jury is different. It's the luck of the draw. This is who wrote this?
Their lawyer. Hold on. What
Did they
page
go
am I
to the
on?
same
4?
school Jingers did?
I don't know. It's
'Cause the logic
Mark
is
Diller.
so. Oh well, never mind. You'll meet him soon.
I was gonna say I don't know these people by names yet because there's so many lawyers. I'm not even kidding how many lawyers there are. There's so many. We'll get to know them by names. And next time,
He's very prolific. He's a main character.
he seems like it.
Yeah.
The only spicy
Yeah.
ones I've read so far have been written by him. If this was standard, I would win all my Ray trials. Oh goodness. All right. So they're like, yeah, they would totally more likely than not that O'Keefe, she caused the wrongful death. Anyone familiar with the O.J. Simpson case understands that there can be disparate outcomes with similar sets of facts, not only because the civil standard is lower, but also now the jury gets to assess the credibility of the alleged wrongdoer. By the way, those 2 cases are not the same at all. At all. We won't get into that whole 11th month trial, but I get the comparison because I did the comparison for the civil criminal, of course, but like they're not the same. Plaintiffs here are entitled to civil discovery, including the under oath testimony of Karen Reed, not only to hear her version of events, but also to assess her credibility. Plaintiffs noticed Reed's deposition for December 5th, 2024. So they want to do a deposition of her before her second criminal trial. And they're like, well, I don't understand why she doesn't want to do this. You mean so you can hand that shit over to the state, the already corrupt bullshit that they have going on? I don't think so. Despite her contention that proceeding with civil discovery could compromise her defense in the criminal prosecution, Reed has repeatedly emphasized that she wants to talk and is eager to provide her account of the events in question. Indeed, she has addressed the matters publicly on several occasions, making her own narrative a prominent part of the public discourse. Moreover, there is no shortage of reporters, bloggers, and persons claiming that Reed is actively speaking about the facts. This public engagement raises troubling questions about Reed's true intentions. Okay. All right. Wow, Dylan. Okay. If Reed genuinely has concerns about her statements being used against her, it seems contradictory she would continue to speak out so openly. Right, but also not the same, though.
Yeah.
I mean,
Okay, but I did have issues with Karen talking too much before
yeah,
for her
it
criminal
wasn't smart,
trial.
but her lawyers gave it the okay, so she did. I
I
don't
mean,
know.
I understand. I understand.
I
I
mean, because
understand she got the okay.
we watched the Karen doc on HBO, I think it was the one that does the trial. By the way, say cheese. There's also the good behind the scenes like trial of the first one, like them with the camera following them through the trial. It's really cool. We watched that one and we were just like, oh my God, they're definitely going to use some of this.
Oh, well,
And
I
they
don't
did.
think that documentary went the way they thought it was going to go.
No. I enjoyed it because I love kind of like the behind the scenes war
Yes,
rooms and things
but
like that. But yeah, no.
from what I understand, she was not happy with the.
Hey, Terry. Yeah. Yeah. This motion borderlines on frivolous. Sometimes you have to tell your girl. Oh my God. These people say you have no idea. Frivolous is just like the common word for everything involving all of all of these cases. It's wild. And then also, with the Lindsay Clancy case that's also in Massachusetts with some of the same state witnesses. But a lot of us that watch Karen Reed, as we're watching this, we're just like, oh, you guys are going here again. Oh, we're doing this again. Got it. I don't trust the DAs over there in Massachusetts. Let me tell you what. Most of them, not all of them, but some of them I am very questionable of and their reasons behind things. Anyway, put it this way, say in the second trial, they hire a special prosecutor. They bring a special prosecutor on named Hank Brennan, who isn't actually a prosecutor. He is a defense attorney and he is a mob defense attorney. hmm He represented Whitey Bulger. And guess how much they paid him? Over $500,000 to try Karen Reed a second time. $554,000 they paid Hank Brennan. Yeah. Yeah, dude. It's so corrupt, say. It's so corrupt. I'm telling you. It's wild. It's wild. Anyway, back to this. I'm sorry. Where was I? Okay, so by actively participating in public discourse and potentially profiting from media engagements, Reed effectively foregoes any claim of Fifth Amendment protection, which is a wild take. I don't think that happens, but okay. Karen Reed's choice to speak out starkly contradicts any suggestion that she is concerned with self-incrimination. Now Reed comes here asking the court to allow her to have it both ways. Furthermore, the O'Keefe family has compelling reasons to pursue their claims with urgency, as there are legitimate questions in this case regarding witness and jury manipulation. There is. There is. The call was coming from inside the house. Sorry. Not sorry. Further delay not only affects witnesses and jurors, but also the O'Keefe family, who have been dealing with the loss since January 29, 2022. And I've said this and I said this then. The family is entitled absolutely to feel how they feel about anything. I mean, they are the people who lost someone, and I get that. My problems with are everybody else and kind of Paul, 'cause Paul kind of sucks, but still, I'm not surprised his family has filed this suit, but I think they put their horse or what they bet on the wrong horse, in my opinion. But anyway, the first criminal trial extended beyond a full calendar month, and the second trial is not set to begin until more than 4 months from now. Furthermore, there is no assurance the additional delays, another mistrial, a lengthy appeal, or other legal complications will not arise, extending Karen's authority to postpone the civil proceedings, which I do kind of get. Like, how long are we going to actually kick the can down? Okay, I'll give you that little bit. However, it doesn't go with the others. If she chooses to plead the Fifth Amendment in the civil proceeding, she may do so with she may do so with consequence. However, if she wants to speak under oath as freely as she does for the media and others, plaintiff welcomes the opportunity to obtain her testimony. I don't think those are the same thing. By allowing the civil case to proceed, the court demonstrates a commitment to transparency and the timely resolution of such serious matters, which is crucial to maintaining public trust in the legal system. Oh, that's a bold claim. Bold claim about public trust in the system there in Massachusetts after all this. Okay. Okay.
Right.
And there are many people who do, but I don't.
I think there's a lot more people that don't.
Yeah, at this point, there's a lot more people that don't. That's for damn sure. A stay would only delay justice and could foster frustration among the public who are closely watching both proceedings and expect the court to take decisive action. What does the public have to do with anything? Doesn't matter. Like, who cares? Okay. The public's confidence in the legal, I mean, you can put just your clients. That's more reasonable than the public. Who cares? The public's confidence in the legal process depends on seeing justice served in a prompt and effective manner. Denying the stay ensures both the civil and criminal matters are addressed on their own merits without unnecessary postponement that could undermine public faith in court's ability to handle such high profile and sensitive cases. While Karen Reed argues that civil discovery should be stayed to protect her Fifth Amendment rights, her actions say otherwise. By openly discussing the case in various media outlets, Reed demonstrates a clear intention to influence public perception and poison the jury pool in both her civil and criminal cases. This selective invocation of her rights undermines the very protections she seeks and raises serious questions about her motives. You mean not going to prison for the rest of her fucking life? Okay. Under the circumstances, it is reasonable to proceed with civil discovery, allowing both parties to pursue their interests while ensuring the judicial process remains fair and balanced. So that is their objection to that, which I thought was very interesting. I feel like he could have said a good point without like dragging her through the mud, but that's just me. I don't know, but to me that seems a little unnecessary.
Buckle up,
Um,
Buttercup.
Yeah, there
Because,
really wasn't. There was like 3 things of case law, and I'm not gonna read all of the case law. It was a whole legal standard one. There's 3 paragraphs, 4, 5 paragraphs. But we don't have time to go through all of their arguing of case law. But yeah, it's not very much. Your birthday and Laura's search warrant was the same day. I love that for you. That's amazing. Oh yeah, and another $500,000 for the worst expert you will ever see in your life. Say cheese. 2 of them actually. Aperture had 2. You're gonna lose your mind. The DA had to ask the state legislature for an additional $1 million for this retrial. I forget what was the number. They said after the fact, they told it wasn't like $4 million or something like that to try Karen Reed in this bullshit. Oh, it's quiet. It's wild. Uh-huh. Well, well, it's a lot unless you're trying to protect the cops. Say cheese. Then spare no expense, the state sees apparently. It's insane. I honestly, you should just start a YouTube channel and watch it. I'll watch you every single second of the day to hear I'll watch it all over again to hear your commentary of what is happening from beginning to end with both of them. Yeah, Ian Whiffen is going to be, so he was like a digital forensic expert. He's one of the reasons now so many of us question Celebrate based on that. But oh my gosh, the blue man test, it's ridiculous. It's ridiculous. That would be fun. I'd watch it. All right. So the plaintiffs file, their opposition. I don't know how to. Oh, that's just me. Hold on. I lost you, Buffy. Sorry. There we are. There we are. All right. So then, October 3rd, 2024, the day after, the Waterfall Bar and Grill finally get some lawyers, I guess. I don't know why it took them so long, but they did. And so they get David Hassett, John Dealey, and Casey McCaffrey from the law offices of Hassett and Donnelly. I'll be honest, I don't know if there's any lawyer in Massachusetts that's not a part of one of these civil cases, because I'm pretty sure all of the lawyers are. But so now they're represented as well. So now all three defendants have counsel. Let's see. So then on October 18th, the Waterfall Bar and Grill also asked the judge to grant the motion move for a stay in the case until after the retrial takes place. Because they're like, we could use that extra time, probably. No, their reasons are that it will preserve the parties and witnesses' resources, promote judicial economy, and it carries little risk of prejudice to the plaintiffs. Like, yeah, it's going to be happening soon anyway. What are we doing here? To which Mark Diller, plaintiff attorney, guess what? He has something to say about it. And of course he does. I think it's funny that you said that
I
he's a very, and I didn't even know that.
told
I just read these and I was just like, oh, sir, you
I would
are
say,
just,
yeah. Get ready because
because guess
I
what?
recognize that I am not even following this case extremely closely, closely enough that I've seen some of the hearings and stuff, but I don't know everything, and I know his name. That's all I'm gonna say. It's just like, oh, yeah, that makes sense.
Yeah, you think they will use the self-qualified Shannon Burgess as a witness this time? No way, that guy lost his job. She should have. Oh God, it's such a short show. Oh my goodness. What a time. What a time and what kind of trials. What kind of assets does Karen Reed have? Didn't she have to raise
She
money
has
for her defense? She
nothing
has none.
now.
She has nothing. She had to sell her house. They were able to raise like $1 million in her defense, but she had to sell her house. She wasn't able to work because she lost her job because of the accusations. I mean, partially that's why she's done paid interviews is to help pay for defense. Her attorneys, correct me if I'm wrong,
They
but I'm
did
pretty
this
sure we're
second
pro
trial
bono.
for
The second
basically
trial
free.
was, yeah, was basically free. They used the money for the experts, and that was about it, because they believed in her case so much, and they're not wrong. And now for the civil suits, because as I said at the beginning, there are 4 going on right now, 4 different ones, and some of them she's gonna win some. Okay, she's gonna win some. She's gonna win some money off the cop one. I'll tell you that. That's for damn sure. After they released those Proctor uh, deplorable messages. We'll get there. We'll get to that trial. Don't worry. There's 4 of these, and this is the first one we're covering. So, yeah, not to mention her health issues because she has MS. She has been put through the ringer from this bullshit. Let me tell you what, I do believe she is factually innocent. Hands down. You cannot convince me otherwise, period. In this case, there's very few people I find factually innocent, and I do believe Karen is factually innocent here. So anyway, so Diller, right? Was that his name? Mark Diller? I forget already. I'll learn these people's names. Make sure.
Yes, Mark Diller.
All right. Yes, he did file this one too. Again, in objection to now the Waterfall Bar wanting a motion to stay. All right. So they want, a stay. Well, guess what? The plaintiffs oppose defendant Waterfall's request because the potential for duplication of resources is overstated, which is a ludicrous take, and does not outweigh the prejudice that will burden the plaintiffs should this court order a stay of the civil proceedings. First, the potential for duplication of resources fails to recognize that discovery in the civil case extends beyond the relevant inquiries of witnesses in the criminal case. Second, Waterfall's assertion that a brief stay poses little risk to prejudice to the plaintiffs is inaccurate. Not only is defendant Reed using the media to poison the jury pool, but also any delay risks the degradation of evidence, including witnesses, who, by the way, are about to testify again in another trial, but sure. Sure, Mark. I'm sorry, including witnesses' memories. Therefore, the purported concerns over duplication are outweighed by the hardship and substantial risk of prejudice plaintiffs would face should a stay be granted. States some case law. It's obviously, here you go, say cheese, a whole page. If that help. Oh, you know what? I'm not even sharing the right one with you guys. I'm sorry. My bad. There we go. Sorry about that, guys. There you go. Whole page of legal case law. Defendant Waterfall overstates its concern that allowing civil discovery to proceed will force witnesses to testify in overlapping proceedings because witnesses can participate in both the civil and criminal matters without undue burden. Which, if a criminal trial is going on, that's supposed to take 3 months. How are you going to schedule around a schedule that kind of has to ebb and flow because you don't know how long somebody, delays and stuff. You don't know. But okay. Only a few of the witnesses relevant to Waterfall's liability here overlap. For example, many of the ownership and or staff of Waterfall are not expected to testify in Karen's criminal case, even though they are expected to testify in the civil case. Moreover, facts relevant to the criminal matter for Waterfall employee agents do not align with the civil matter, and the inquiry is expected to be wholly different in the civil case. The operative timeline relevant to Waterfall's ability does not align with the relevant times in the Reed criminal matter. The time of Reed's drunk driving, which doesn't make sense. This instance, the operative time relevant to Waterfall's liability, times of service, does not align with the relevant times in the Reed criminal matter, the time of Reed's drunk driving. I don't understand what that's supposed to mean. So they not match up? What are you saying? Because they seem to match up in court. There was detailed timeline.
Because I guess what they're saying is they're going after the Waterfalls part of it, not the actual Reed driving part of it. So Reed's drunk driving doesn't really matter. It's the Waterfalls liability.
Oh, yeah. Okay.
Served.
It's not relevant to that. Okay. Thank you. Yeah, that does make sense. Yeah. I'm telling you, there was LawTube had a heyday with Karen Reed in those trials. Like it's truly unbelievable. Say cheese, truly unbelievable. How much were they served? In total, I believe Karen said she had about 9 drinks that night. 7 at McCarthy's, and then a shot and a drink at the Waterfall, which is who we're talking about right now. And that's the number they're claiming here. But I believe she said a specific number in the documentary, and I was like, "Damn it, Karen! Probably should not have said that." But
should have said that.
Whatevs. But yeah, no, that definitely makes sense. All right, so where was I? Anecdotal testimony of Reed's visible intoxication at Waterfall from other inebriated patrons of the Waterfall may not carry the same weight as bar staff who were supposed to be trained professionally to identify visible signs of intoxication. The O'Keefe family also has compelling reasons to lock in testimony from Karen Reed, who seeks not only to poison the jury pool with her regular communications with the media, reporters, and or bloggers, but also has 1 foot out of Massachusetts now that her house has sold. You think she did not sell that nice ass house because she wanted to. It's because she had to pay for this bullshit charges against her. Hello, Lie. Like, I don't know how to say her name, so we're going to go with Lick. How's that? The latest FOIA docs include an HD pic of Karen's car at John's house. The taillight is smashed into oblivion. No one wants to point that out. And which case is that for? Because there's 4. This is only the O'Keefe one, and we're just starting from the beginning. By the way, I would like to know. I don't know. We're kind of new covering the civil trial, so I don't know anything that you're talking about yet because we haven't got there. But let me know which trial that is or which case that is because I would like to know for sure. All right. Let's see. Moreover, the risk of witness memories fading and or relevant witnesses from Waterfall moving on with their lives and being uncooperative is not insignificant. And the O'Keefe has right to timely resolution. So based on Waterfall's request, a stay here could be indefinite, additional delays because of the criminal trial and all the other reasons they said there in the first one. Okay, so again, they're still like, but Karen's talking to everybody in public. So the answer should be no, Your Honor, no. All right, so then on October 28th, 2024, C.F. McCarthy also files a motion to stay and join in with the Waterfall Bar and Grill for the same exact reasons, right? Let's save our resources, the criminal trial, who cares? Of course, the plaintiffs object, same stuff we've read in the last two of their objections. You know, Karen's talking to everybody, and this could go on forever. And a hearing on the motion to stay is held on the 28th of October 2024. And then on October 31st, 2024, the judge does issue an order. At this time, the judge on the case is Judge William White. That will change, but for now, he is the judge that we'll be talking about today because he's originally on this case. And the judge determined that Reed's media statements did not constitute a waiver of her Fifth Amendment privilege. Because again, like, I don't see how it is. But okay. Because the critical issue in both cases is whether Reed hit O'Keefe with her vehicle, there is substantial overlap that implicates her privilege against self-incrimination. The court found that the risk of faded witness memories was low due to the extensive prior investigations in the completed first criminal trial, that any potential jury bias from media coverage can be managed through standard individual voir dire procedures during jury empanelment, which, hey, the criminal case had to do it twice, you know, and everybody, like, they had to seat two juries. It's no different here. Okay. One trial already happened and they need to set one for a second one. So there's that. The court also ruled that a complete stay of the entire lawsuit, though, was unnecessary and that a tailored partial stay would best serve all parties. So the motion to stay were allowed in part and denied in part. So what was allowed was the scheduled deposition of Karen Reed and any other discovery directed specifically to her were stayed pending the resolution of her criminal trial. So they don't have to do anything at this point in time. But what the motions that were denied are all the other aspects, meaning every other aspect of civil litigation, including the waterfall, including C.F. McCarthy, anything not involving Reed needed to go ahead and proceed without it, right? That's his order. I think that's a pretty fair order.
It sounds pretty fair. What
That sounds
happened?
pretty fair. What happened? So then December 10th, 2024, the Waterfall Bar and Grill adds another attorney, John Donovan III, from the law offices of Sloan and Wash to their legal team. So again, people are starting to add extra people to their legal team, which is interesting. But I think, yeah, I think it would be not there'd be a lot of problems if she was set to be deposed. Like,
Yeah, I mean, it seems like it's fair just on its face, it makes sense to me. So,
right. I'm like, okay.
but they could have kept going with their lawsuit, or they just had to wait for Karen Reed to be done.
Exactly.
Like they could have kept going with everything else. There was no reason to,
No reason for any of that, really. Could
No.
have just been, I mean, I get that, it could be, indefinite, right? Just kicking the can down the road with her.
That's
If she
literally
was found
everything.
guilty, if there was appeal, but, he's like, nope, anything to do with that, forget about it. So
Every civil case ever.
right, as we're learning. Now that we for somehow have found our case this year, or in this year we found ourselves in civil cases out the butt, which is weird because you and I don't normally like even watch
No.
or anything, and that's what we've been focusing on, which is very funny to us. So, so it does make sense, right? Yeah, I thought, that makes sense. This is absolutely the normal procedure instead of civil litigation stemming from alleged criminal conduct, right? And it's not like, again, the next trial, because she never waived her speedy trial rights for either one, which was smart, you'll see. So it's not like it's going to be 4 years from now or something like that. But even then, wouldn't they usually still stay because of it? I would think so. I don't know. All right. So now let's move on to 2025. So not much happens in this O'Keefe v. Reed bar case between December 2024 and March 2025. Karen's retrial was scheduled for the end of January 2025, but as we all know, it got pushed to April and opening statements were made April 22nd, 2025. So not a lot was going on. But it does start to pick up again on March 24th, 2025. This is about a month before, well, this is about what, a week before jury selection? Because weren't they jury selection for like 3 weeks or something? I think. Yeah, I feel like they started at the beginning of April, jury selection, and didn't uh openings weren't until the 22nd. Because we watched Lori Vallow while they were doing jury selection. So all right, so on March 24th, 2025, attorneys Damon Seligson, is that how you say it? I haven't heard his name pronounced yet, so I don't know. Damon, we'll call him Damon. And Aaron Rosenberg sign on as counsel for other interested parties in this case, specifically William Reed, Karen's dad, Janet Reed, Karen's mother, and Caitlin Bordeaux, who is Karen's sister. But in all of the legal things, they say she's a sister-in-law, which is very confusing. I don't understand why it said that numerous times. But I'm pretty sure that's her sister. Also, if it was her sister-in-law, wouldn't her last name be Reed?
No, her sister is Kelly. I think
then
it is
who's
her
Caitlin?
sister-in-law.
Well, then who's
I don't
Caitlin
know.
Boudreaux?
That's her sister-in-law.
That is her sister-in-law?
I believe so.
Okay, well, then that makes sense, I guess. But why would her brother have a different name?
Why does anybody's brothers have different names? Unless it's her maiden name.
Does she have a brother? Okay. All right.
Yes.
Well, I guess it is her sister-in-law. Okay. Karen's older sister is strange. All right, whatever. We're not going down that rabbit hole. But okay, so that is her sister-in-law, Caitlin. Okay. That makes more sense because I was like, why did they keep saying that? But whatever. Did she testify in the second trial? I don't think she did. Did she do in the first one?
No.
Okay.
None of her family did, I believe. I don't remember any family members on Karen Reed's side.
Oh, you come back with FOIA docs were requested by a lawyer who filed the case, Corey Hopkins, a big Karen supporter. The big surprise was the docs contained a pic that proves Karen's taillight wasn't broken by cops. Oh, does he have a YouTube channel? Or where can I find that, please and thank you? That's true. Not all women change their name when they get married. Yeah, that's true because I already said I wouldn't have got married. So that's fair points. Anyway, all right. So Damon Seglison and Aaron Rosenberg are now representing Karen Reed's family members, and they file a motion for a protective order postponing third-party depositions until after the criminal trials because they're trying to the plaintiffs are trying to depose her family at this point. And I believe they might have been on the witness list, but I can't recall. But of course, the plaintiffs opposed their motion, right? Like, well, they aren't Karen, so they can be deposed. But even that's kind of. So then on April 8th, 2025, while they're in jury selection over in the criminal trial, attorney Daniel Buck appears on behalf of Paul O'Keefe and as the personal representative of John O'Keefe's estate. So they get an additional lawyer because no one's withdrawn yet. They're just adding lawyers. Motion hearing is held, and it doesn't seem to be available online, but the judge ruled that the plaintiffs shall not be promoted to depose Janet, William, or Caitlin for a period of 90 days or upon the conclusion of her retrial, whichever comes first. So that was pretty nipped in the bud. Again, I get why they're wanting to go after all of their deposition first, but why don't you just go after all the bar employees and all, like there's plenty of other people that aren't, why aren't you doing them first, Because they want what they're going to say for a reason, I feel, but that's just me.
Yeah, I mean, usually depositions, like I was telling you earlier, are strategic.
Oh.
You want to ask certain questions to certain
It's
people,
true.
so you know what questions to ask of other people. So while you can do them, like how do you know what to ask until you know what to ask, right?
Yeah.
So, and just to let you know, Caitlin Boudreaux is Karen Reed's sister-in-law. She's married to Karen's brother, Nathan Reed, although she is often listed in court documents under her maiden name, Caitlin Boudreaux.
Okay. That makes a lot more sense. Okay. So I don't know Karen's family history. I don't know any of that. I don't particularly, it doesn't really matter in the grand scheme of things here, but okay, that does make a lot more sense now.
And
All
she
right.
was not called to testify. The Commonwealth added her to its witness list, even though she was not called to testify during the trial. So she was on Commonwealth's witness list, but she never testified.
Okay. So July 2nd, 2025, this is after the not guilty verdict has come in for Karen Reed's retrial. Attorney Kevin Burgin withdraws from representing C.F. McCarthy. So they're down a lawyer now, but they still have others. Then on July 3rd, attorneys Aaron Rosenberg, Charles Waters, and Damon Seglison, who were representing Karen's family members, are now on Karen Reed's civil defense team. They've now joined to represent Karen.
Rosenberg and Waters. So I feel like those are the ones I hear mentioned the most often because, like I said, I haven't followed in depth with the documents, but I did watch the hearings. Those, it's Diller, Rosenberg, Waters. I feel like we hear a lot of.
Okay. Isn't Damon, because I vaguely remember the first hearing in this case that was live. Is he the one that's from Australia? Because one of them has I believe, Australian accent.
It's not. I thought it was South African.
Maybe it's South Africa. Okay. Hey, I am not the best at separating these accents here, but one of them has a very strong accent. Is that Damon?
Yeah, I don't remember his name.
Oh, okay. Okay. Well,
Like
we'll find out because we're going to watch it
I
today.
am not in depth. I kind of I kind of get bits and pieces what I could keep up with when I'm not on the other stuff. So
Right. Well, we'll find out today because we are going to watch the hearing I just referred to. We're almost there, friends, I promise. So then on July 7th, 2025, the case is then sent to the Plymouth Superior Court, which is where you can find the documents if you want to read them yourself. Make sure that when you do the case search for it, you put in Superior Court and then Plymouth County or Plymouth, and it'll do Plymouth again. And then you put Reed's name in there. That's how you find all of the case information, everything like that. So then on July 9th, 2025, Karen Reed serves the plaintiffs with her motion to dismiss. And August 12th, 2025 is when we find more about what exactly and why she wants this to be dismissed. I mean, besides the obvious. So she files her memorandum of law to support her motion to dismiss. So Karen's lawyers are asking the court to throw out counts 10 through 13 of the lawsuit. These specific they want the whole thing thrown out, of course, but these specific parts of the lawsuit accuse Karen of causing the family severe emotional distress. And Reed's team argues that under Massachusetts law, these emotional distress claims are not legally valid because the family members did not actually see the accident happen and their emotional pain is already covered under a separate wrongful death claim. So I think they're implying that they're double dipping is what they're going for here as their argument. Whether that's true or not, I don't know. I'm just saying what the document said. They cite Rule 12b-6, which we're going to hear a lot about. All right. Rule 12b is going to be like our Rule 26. So prepare yourselves, friends. Prepare yourselves. There's
Oh
always one in
man.
every case,
Okay.
right? uh, thank you. People get very culty about it online. You seem like good people. Don't get into arguments with the crazies. Nah, I agree. I mean, we're just here because we like talking about cases. Some people may not like what we say, and that's okay. But it's, we'll see. We'll see what people think
Hey,
about it, but it's fine.
it's not our first rodeo.
Not our first rodeo, that's for damn sure. Also, we generally have unpopular opinions, so it's fine.
Yeah, we're used to that. We
We're
have a
very
lot of
used to that.
unpopular opinions.
Boy, do people love to tell you about it. Love it. Anyway, but thank you for that. That's very kind of you to say, and we appreciate that. We try to be as fair as we can be, even going into these civil suits, right? Even though we have our, how we feel about the criminal trials, the civil suit is also a new trial. You got to go into each one open-minded the best you can.
Let's talk again when you get to 2026.
I was gonna say, yeah, I know that this gets way worse, and we will get to 2026 next week, I promise.
Let's revisit that statement once we get to 2026.
We're gonna try our best. But, ugh. All right, so they're arguing that they're double dipping here, right? So they cite Rule 12b-6, which we're going to hear a lot about. The judge must use this to decide whether to throw out these claims. He must look at the family's complaint and assume their factual stories are true. However, just making vague accusations or legal conclusions without solid specific facts backing them up is not enough to keep a claim alive. And I think in this, the plaintiffs are saying, "Oh, Karen did this time, this all happened. She hit him, blah blah blah." But they haven't stated their facts yet. But again, it's only the beginning, so that's what they're arguing. They also argue that the emotional distress claims from O'Keefe's mother and father should be dismissed because they are the legal next of kin. Any compensation for their grief and loss of companionship is already packed into the wrongful death lawsuit and cannot be double counted as separate emotional distress claims. They also argue that the emotional distress claims failed the legal test because the family didn't properly separate their claims for negligent, which means careless, right? Distress versus reckless, which is intentional distress. Two very different things. All right. So let's break that down. The negligent distress is that they weren't there, the plaintiffs weren't there. So to sue for careless emotional distress caused by an accident, a relative must closely witness the accident or arrive immediately after. Again, this is what their document is saying. Okay. Because the family only saw O'Keefe at the hospital at least 7 hours later, they legally cannot claim this. His niece only heard about it through conversations, which also doesn't count. And then there's the reckless distress claims, which is they're saying that Karen's behavior wasn't outrageous enough for this. Because to sue for reckless distress, the behavior must be completely intolerable and shocking to society, which I'm going to say they don't have me on this one already at all, but that's okay. We'll see. The defense states that Reed defending herself against criminal charges or speculation about what happened does not legally qualify as extreme or outrageous behavior targeted at hurting the family. Regarding Kaylee, the niece's claims, the defense argues that waking the niece up, speaking on speakerphone about the situation, and driving away in an SUV are not actions that are utterly intolerable in a civilized community. So her claims should be dismissed too. Yeah, I don't really get the Kaylee claim, but I guess when you're filing something, try to throw all the stuff there and then, see what doesn't work out there. I mean, is it great to wake up a kid? No, but it's not like outrageous enough, quite frankly. Um, but we'll see. So that was their memorandum of why Karen wants the case thrown out. The same day, which is we're still on August 12th, 2025, the Waterfall Bar and Grill joined Karen's motion to dismiss, and that if the court grants hers, then they would like the counts that apply to them dismissed with prejudice as well, please and thank you. Because Karen's was with prejudice as well, which means, if you don't know, with prejudice means that it can't be brought up again. She can't be recharged with it, or you can't complain about it again. It's been decided. So the Waterfall Bar and Grill is like, yeah, can you, if you do that, can you do us too, please? Please and thank you. And also the same day, CF McCarthy's joins Karen's motion to dismiss. And again, same thing. If you dismiss hers, can you dismiss ours with prejudice, please and thank you? Okay, great, thanks. So then the plaintiffs come in and they oppose this dismissal motion to dismiss, because of course they do, and they should, right? That's just how court works. It is like 55 pages, but don't worry, there's really not that much to it. A lot of it was filings, previous filings. So
Say 55 pages. It takes us 4 hours to read 40.
yeah, don't worry, we're not reading it, friends. I promise we would try to catch up quickly. And I took all the highlighted parts. Don't worry, if there was something good, you're going to know about it. So they start off, the family states that they have suffered immense emotional trauma from John's death. They claim this pain has been made much worse because Karen and her supporters have continuously harassed, ridiculed, and targeted them with a disinformation campaign to hide the
I've
truth.
heard this one before.
The O'Keefe family argues that their emotional distress claims are fully legitimate and need a deeper look at the facts. They're asking the judge to reject Reed's request to dismiss the case so they can move forward with discovery. And these are some of their arguments. The first argument is the negligent infliction of emotional distress is an independent cause of action, separate and distinct from wrongful death damages. So they're going to tell you why they're not double dipping. So Reed's argument, again, was that any money the family could win would overlap with these, right? Because it's already covered under the wrongful death law. And so the plaintiff's counter argument in this motion is that the family states that Karen's argument has no backing in law. They explain that under Massachusetts wrongful death rules, family members are strictly forbidden from receiving money for their personal grief, anguish, or bereavement. Now, here the family also points out that a claim for a negligent emotional distress is entirely separate from a wrongful death claim. Because while wrongful death compensates the family for the loss of value of what the deceased person would have provided if they had lived, an emotional distress claim specifically protects individuals from the severe psychological shock of experiencing or witnessing the direct consequence of a defendant's harmful behavior. Therefore, the remedies do not double up and the claim should be allowed to move forward. So I don't know how close that is to being, correct, but that's what they're arguing. 2, the complaint alleges sufficient grounds to hold Karen Reed liable for negligent infliction of emotional distress. Right? Karen argues that the court should throw this out because the shock they experienced was not close enough in time. The plaintiffs argue that the Massachusetts courts do not use a strict, rigid timeline to judge these situations. Instead, the law focuses on whether it was reasonably foreseeable that the family would suffer severe shock based on where, when, and how they found out about the injuries, which I don't understand these arguments. I really don't, but okay. They point out that at this early phase of the lawsuit, the legal standard is very generous, and the family only needs to show their claim is plausible enough to move forward into the evidence gathering stage. And I say this, why I'm kind of confused about this is because they had only went to the hospital to see John, which is traumatic. It really, I know. I've been there recently. It's pretty traumatic experience to see a young loved one deceased in the hospital, but a lot of people have to see that after accident, things like that, that I don't know. I don't know if it really would do a lot for me as a juror. Like, okay, but I don't know. I mean, it's devastating and it's tragic, but
I
I
mean,
don't know.
it's civil. I think everybody tries to sue for like literally everything. You know what I'm saying? Like
Yeah.
it's always, an emotional distress, loss of wages, da, 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 da. Like it's just like I feel like it's just
Hmm.
one of those that gets thrown in the pile
Yeah.
usually.
They also go on to argue that rushing to the hospital and witnessing the immediate devastating consequences of the event counts as happening closely on the heels of the tragedy, even though it was still like 7 hours later. Furthermore, they highlight that Reed's harmful actions didn't stop at midnight. She spent the early morning hours abandoning John in a blizzard and trying to create a cover story extending the timeline of her reckless behavior. I cannot stress enough, as a Northerner, that Massachusetts kept perpetuating. It was a blizzard at the time when it most certainly was not during these hours. Snow had fallen, but not near as much. He was still clearly visible in that yard, despite what other people want to claim. Uh, it wasn't that very much, and Massachusetts knows better. But okay,
To track a cat.
okay. So then their argument regarding Kaylee, the 14-year-old niece, Karen argues that, her claim is invalid because she did not actually see the car crash or view John's body at the hospital, that the family strongly rejects this argument, stating that people can experience severe psychological shock through senses other than just sight. Well, yeah, that can happen, yes, but all right. Um, they emphasize that Kaylee, a vulnerable teenager who had already tragically lost both parents, was abruptly woken up at 4:30 a.m. by a panicked, screaming Karen, and Kaylee had to listen to Reed claim she hit John and proclaim that her surrogate father was dead, all while Karen forced the teenager into a chaotic cover-up attempt before abandoning her home alone. That's a little embellished, if you ask me, but okay.
What was the
They wanted
cover up attempt that she tried to get Kaylee involved in? I need
I
a
don't
little bit more elaboration on that.
I have no idea. I have no idea. The family argues that forcing Kaylee to experience the direct psychological fallout of the crime is more than enough to let a jury decide her claim. I mean, hey, I'm not saying it wasn't tragic and emotional for Kaylee. She is 14. That's a lot of death for a
Mhm.
14-year-old to experience. Absolutely. But this doesn't, if so, then we can't express when we're panicked about something because a child, it's just not realistic, I guess is what I'm saying. You know, plus she has a younger brother, right? Honestly, if it was me, I would wake up the older kid and be like, this is going on. I have to leave the house to go figure out this stuff. Stay awake, you know, protect your brother or whatever. She's
Right.
14 years old, leaving her at the home alone. Like, come on. It is
Well,
reaching, in my
she's
opinion,
14.
regarding Kaylee here. Again, though, not to take away from the tragedies that she's experienced at all, because that is all very, very real. Their next argument was that the plaintiff's complaint, viewed holistically, suggests that the O'Keefe family is entitled to relief for Reed's intentional, reckless infliction of emotional distress. So the plaintiff should be afforded the opportunity to conduct discovery. So, Karen Reed's argument was like, dismiss this because the family's complaint lacks highly specific details and that her alleged actions were not extreme or outrageous enough to meet the legal definition. So, their counter argument, the plaintiff's counter argument, is that the family states a lawsuit cannot be thrown out at this early stage just because it lacks hyper specific details. Instead, the judge must look at the whole picture, meaning the combined impact of all the facts taken together. And they emphasize that the court should view Reed's actions in the worst possible light allowed by the facts and let a jury decide if her behavior crossed the line into being extreme and outrageous. So I'm not going to rehash Kaylee's claim. We've already done it several times. The parents in Paul's claim, they say that Karen claims she cannot be held responsible for intentionally hurting the rest of the family because her actions weren't directly aimed at them. But the family counters that under the law, an intentional distress claim doesn't require proof that the defendant acted out of pure spite to hurt them. Even though they talked about a conspiracy that also hurt them. So I don't really, okay. It is enough
But
to
is that
show,
just the law? The law
I don't know.
says it doesn't have to be out of spite, even though that
Right.
they're claiming it was out of spite. So it's
Right.
different than what the law allows.
It is enough to show that Reed engaged in horrific behavior that she should have known would cause them severe emotional wreckage. I mean, anybody in these kind of cases have that, especially it's a public case. Like, yeah, happens in every single case that's out there. So I don't know. And then, of course, the secret disinformation campaign. So, to prove Karen's intentional misconduct, the family points to public records from her criminal case. These records indicate that after her arrest, Karen secretly used an intermediary and an encrypted app to feed non public information, autopsy photos, and defense theories to a local blogger, Turtle Boy. Oh boy.
Dun, dun, dun.
Turtle Boy has entered the chat. Don't worry, you're going to be hearing a lot about him too. She allegedly, so the plaintiffs say that she allegedly controlled what he wrote in order to fuel a public campaign that harassed the O'Keefe family, shifted the blame to innocent people, and publicly declared that the family's grief period had expired. The family argues, yeah, that's pretty. Did she say that? I don't know. They put it in quotes.
I don't know.
Those are their quotes that Karen publicly declared that the family's grief period had expired.
That's just,
Or maybe Turtle Boy said that. I'm very confused, but either way,
I mean, I don't
they're
know.
making it
Like I
sound.
said, I'm trying to put away everything I do know and just focus on what's being said.
They're saying Karen said that.
Interesting. Wow. I don't think I've ever heard that before, but okay.
Because she allegedly controlled what he wrote and publicly declared that the family's grief period had expired, which I don't know. I don't know if she said it or not. The family also argues that orchestrating a massive public disinformation campaign against a grieving family is entirely extreme and outrageous, and they deserve the chance to uncover more evidence through discovery. They asked the judge to deny, and again, this is now after her second trial, after she's been acquitted, found not guilty. So they asked the judge to deny her motion to dismiss. There's also a several-page exhibit attached to this 55-page document that goes over Karen Reed and the Turtle Boy connection. But I imagine it's actually all covered in one of the many other lawsuits going on, specifically Ham, Higgins, Alberts, McCabe's versus Karen Reed and Turtle Boy, because I read it and I was like, oh, that's definitely probably over in there. So we're just going to save that for when we cover that, which will be very soon too. That lawsuit just started in June. But I was like, I don't want to confuse y'all too quick. So I feel like that's already being covered elsewhere, and we'll get to that. And we may even use this document in that one. I have to read theirs to see, but it's like 31 pages of.
I'm so interested in that part. I'm so interested in all of it.
I think that one we're probably going to move on to next after this one, maybe.
All of it's crazy.
All it's crazy.
I haven't really read anything on that one.
Yeah,
really, so.
But this one has a hearing next week, so I kind of wanted to. The other ones, I did not see any upcoming hearing dates yet. Not to say there aren't, I just haven't seen them. All right, so they did all that, right? So then Karen Reed replies back to their opposition, of course. Regarding the secret conspiracy plot, her lawyers argue that the family has not provided any factual facts in their lawsuit to back up this serious accusation.
Factual facts like criminal crimes?
Yes.
And
Factual
lawful
facts.
law? Okay. Just making sure.
Criminal
I'm
crime.
writing
Yes.
I'm writing all this down.
So they also say that there's not enough facts for emotional distress, right? Reed's lawyers counter that under the court rules, a lawsuit must already contain enough facts to support its claims when it is filed, rather than just guessing or making unsupported statements. And that there are no delaying tactics here because the family has accused Karen of trying to block or delay their ability to gather evidence. Her lawyers strongly deny this, pointing out that Reed was found not guilty in her criminal trial in June 2025. Before that, the court had paused the gathering of the evidence to protect her constitutional rights, as well as to protect her immediate family members, to be questioned right before trial. So, I mean, she doesn't really seem to be. She seems to be filing a lot of stuff as soon as her trial's over. When was this again? We are still on August 12th. By the way, so the last 20 since Karen's motion to dismiss is still August 12th. I don't know how they got things filed back so quickly on the same day, but they do, which is interesting. They're ready. They also say that there's plenty of time that remains now that the criminal trial is over and the pause has been lifted. Reed's team says they will cooperate with the process. And they argue that O'Keefe's family has chosen not to push forward with gathering evidence on their own. And since the deadline to finish isn't until August 2026, the family hasn't been hurt by the pause. And then Karen then files a request for a hearing on her motion to dismiss the plaintiff's complaint. Then at the end of August 29th, 2025, I keep writing 2026 on my timeline out of habit. That's not right. Change those for later. August 29th, 2025, Damon Segleson, Karen's attorney now, files a motion to admit Alan Jackson, Caleb Mason, and Elizabeth Little, all from Karen's criminal defense team, as pro hoc vice to add to his team. Meaning,
Vice. Pro hoc
Huh?
vice. It's pro
Oh,
hoc
vice.
vice.
Okay. I don't speak Latin. Pro hoc vice. Sure, why not? Everybody pronounces voir dire wrong anyway, so whatever. But I do like that better. Pro hoc vice to add to his team, meaning that even though none of them are licensed to practice in Massachusetts, they do have law licenses elsewhere. This is very normal. Yannetti did this with them for Karen's criminal case, but basically Damon is like their sponsor. Law offices can basically do that. There's a better word for it, but I'm just going to use sponsor because we all know what that, entails. He's taken responsibility.
I just
have
figured
them.
I would help you out because you're
Thank
going to
you.
get 30 comments in the
Probably.
video section yelling at you about your pronunciation. So.
That's fine. That's fine. They're going to add to the list of people that want to yell at me. It's fine. So September 15th, 2025, the judge allows Alan Jackson, Caleb Mason, and Elizabeth Little to join Karen Reed's defense team. And now finally, we are at September 22nd, 2025. The conference hearing, the first one, it's a Rule 12 hearing. And we have finally got here, which is great. Say, geez, I was just coming to correct it. Well, thank you. Pro hoc vice. Thank you for that. Oh, let's see. Angie, sorry, I didn't see this. We definitely all went in with an open mind. I don't know if she hit him or not, but prosecution definitely didn't prove it in either trial. No, they certainly did not, but there was enough to convince me of that. But I mean, that's fine too. All right, so where are we here? Oh, finally, because I gotta go to the bathroom.
I know. I was just thinking the same thing. I was like, oh, I've got to take a bio break.
I know, it's fine. We'll take turns. You go first, so don't worry about it.
Okay.
I get this queued up here. So this hearing, again, happened on September 22nd, 2025. It's only about an hour long. This is also from the trial channel. So you can watch this here if you don't want our commentary as it goes along. She has a whole playlist, as you can see here, with a bunch of different ones. She also has all of her criminal trials on there broken down. No sidebars, no breaks. I love it. So please go over and give the trial channel a subscribe, hit her notification bells, all of the things. So this is that hearing. So let's go ahead and get into it. Make sure my volume's good. I got closed caps on full screen here. Okay.
Good afternoon, folks.
Are we good?
Good afternoon, Your Honor. Good afternoon. All before the court is
Good
2020.
for me.
92. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well.
Get ready.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
He is. Okay.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David.
7 lawyers.
On behalf of Paul Barry.
Hold on. 7 lawyers, and that did not include Caleb and Elizabeth Little. All right. So 7 lawyers just for Karen. We'll throw Caleb and Little in there too, because they should be. So it's 9 people on Karen's team at this point in time. 2 for the plaintiffs. That was Diller and the first 2 that spoke. Diller and what did he say his name was? Buck, something like that. And now we're moving on to the bars. Waterfall Bar and Grill up first.
They have to sit in the
Sorry, you
jury
said
box.
Waterfall?
They had to sit in the jury box. There's so many people. All right, so we got Waterfall.
Got it.
Good.
Also on behalf of Waterfall.
3.
Good afternoon.
Good afternoon, Your Honor. Looking those on behalf of the defendant, CF McCarthy.
Oh, that's the
Good afternoon.
3.
Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery and how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are it is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all
They have
within the
nothing.
next 21 days is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts.
Now, what he just mentioned here, that is the second lawsuit that Karen did file against all of those people he just listed, but is now in federal court. And then this past June, we have Ham v. Karen and Turtle Boy and Karen v. The fourth trial, Karen v. Massachusetts State Police and the city of Canton. So it's still a while before she files just the Canton and Massachusetts one, but she files the other one shortly after this against everybody else.
In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention I'm happy to brief it so that Mr. Dillard can have an
Well,
opportunity.
at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be...
Spoiler alert. It does not go smooth. Nothing goes smooth from what I understand. To the surprise of no one.
No,
they
you
tried.
don't say.
Damon, you tried, you sweet summer child.
For us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you.
But
let's
remember,
hear from-
the judges granting the first stay was only for Karen and stuff, not for these other defendants. Granted, yes, they couldn't get anything from the DA because of the trial, but still, I feel like there's some other stuff you could have done. But okay.
See if McCarthy's then?
Your Honor, on a similar vote as to Waterfall, we are putting official touches on our discovery responses. The last leg of it is just collecting communications from employees in that of the incident, some of whom no longer work for CF McCarthy's, but we anticipate having that completed in a very short term and giving that over to my brothers.
Okay. All right. Thank you. Let's hear from the plaintiffs then.
Did you say give that over to my brothers? Is that what? Did he really say that?
Yes, that's what they refer to their fellow lawyers as brothers.
Okay. I don't know if I've ever heard that used before in court, but okay. All right.
The
I
response.
was wondering, like, does he have a brother on there? Like,
No, that's just what
Okay.
they refer to each other as.
All right.
To the procedural issue that was raised in particular by Ms. Reed's counsel. You were circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started it in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters
Okay.
and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Well, he's
Thank
like,
you, Your Honor.
no. You didn't even tell me about this. This is brand new information that you wanted to bring in all these other people as defendants, as opposed to, witnesses. or, whatever. He's like, how about no? Because what he's arguing, he said, oh, that would probably be a civil court thing. We're not trying to do that. And he is kind of right. Because that's exactly what happened when they filed it separately. But anyway.
We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action.
I love it.
Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally,
Right. So like he's trying to be like, yo, we were thinking about filing this thing, but like we don't even know if you're gonna allow it before we do all this paperwork. Could you just let us know if we should or could, or what's going on, is what I took from that. Like, yeah, we haven't filed a motion for it yet or anything. We're working on it, but we just wanted to give you a heads up. And they're like, yeah, but no though. So, okay.
what my instructions to the clerk's office by setting this event up to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Mm-hmm.
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right?
That's next
I
year,
mean, we
Barry.
can get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach.
I mean,
and it's not intended.
It sounds very unrealistic. I get it. They just like, can we just have one trial for all of this? But like, oh my gosh, even laying out all of just this one case with, 8 parties involved, you have like so many filings where, one person files one thing. Well, then guess what? The other parties have to file the response back and forth. It's so much paperwork to go through. Excuse me. But I can see how this can be problematic, right? Like if you have, this case, the O'Keefe family versus Karen, and then Karen has her, well, now, but this is after this conversation here, but let's say she had, her against, the house party people, the city, all of that. Well, then wouldn't they try to get past the depositions into one as a witness because they're a defendant in the other one? I could see how that delays a lot of time back and forth with those arguments. It's so much arguing and paperwork in these cases. Also, when you see like the lawyers' emails, there's like 25 people CC'd to every email, even if it's only like one sentence. It's pretty wild.
To delay. It's
That is
actually
the
intended to
O'Keefe
try and
family right there.
synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
That's John's mom.
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses.
Damon, I think Buffy said South Africa, and it does sound more South African today than Australian, like I remembered. So I think that's where he is from. I could listen to him talk all day, to be quite honest with you. I might have a little bit of a thing for Damon here, but okay.
To establish that there are third parties who are responsible here, that can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the
That
motion to dismiss?
is-
I have read through your.
There's some of you that never watched the trial. Those are Karen Reed's parents there, William and Janet Reed. Her father is always dressed very snazzy, just so you know. He's a very dapper gentleman. He had quite some good style in the criminal trial, that's for sure. Oh, baby Buffy's demanding food. I know, right? Your kids start school next week. That's pretty crazy. That's okay. Feed the children. They're important.
Material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants. If they want to be heard, you've filed separate motions, essentially arguing.
He's all like, listen, they didn't find out till later. The niece didn't even see anything. She just heard this conversation, and just like we had already talked about, his same argument.
Doing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor, we have the Waterfall, just very briefly. I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many hours later that the parents are seeing the decedent in the hospital. it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated?
Sorry, I think it's kind of cute of the waterfall, like giving an assist to Karen's side. I agree with what they're saying, just so we're on the record. People forget that we're here because we're in the jury box, but we are here. And I just want to say I agree. What happened to this judge? Oh, it gets switched to Galea or whatever his name is because this judge was set to retire, which happens very shortly after this hearing. So that's why they moved it to a new judge, because he was set to retire. And so they didn't want, they figured we'll go ahead and bring a judge on now, who can actually be with the rest of the case to not delay things further. So that's what ended up happening with this judge, who I do very much enjoy.
I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay.
Nope.
All right, great.
Here, thanks.
All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number 3, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today.
Okay.
Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them.
Mm-hmm.
Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically, and 1 to 2 hours
kind of reaching
before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first, the wrongful death statute, it has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based.
Because I haven't followed like all of the internet, thing with Turtle Boy and all of them, but was a lot of it directed at the O'Keefes? I thought most of it was directed at the house witnesses and with the exclusion of Paul, possibly. But, I mean, were people really harassing them that much?
I don't know.
I've gathered that the energy and the frustration is with the state, the law enforcement, and the people at the house. I'm
That's
sure
what I
there have
gathered
been
too.
some that has been focused.
I
at
know the
family.
internet.
There always is. But
I
I
would
feel
say
like
I know the internet, and I can't imagine that there aren't people out there that aren't doing things that they should not be doing to the family. But as far as I'm aware, most of the stuff that I've seen has been directed toward the house defendants and the DA. And
yeah, it rightfully should be. I mean, they did not do very good investigation, and there's a whole
the
big
police
story.
department, and all of those people. So I don't know. I don't recall that.
Okay. Again, I'm sure some do. Because
100%. It is the internet.
People love telling you shit. That's for sure. But I was going to say, I thought most of the vitriol was towards law enforcement, DA, people at the house. But okay.
On emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. that the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself.
Okay.
The liability for NIED depends on number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs.
Okay.
And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not
to be disrespectful, because he's tragically did die, but these were not heinous looking injuries. Well, there weren't as many as there should have been if he was hit by a car, first and foremost. You know what I'm saying? Like, again, not to be disrespectful, because yeah, hitting your head can kill you and does kill you, but like, it's in case those who didn't watch the trial or know, because I know some of you haven't, the argument about John being hit by this car is that he doesn't actually have injuries that are representative of being struck by a vehicle, that one would typically see. So that was an argument from the criminal trials. Again, not to say that, any injury to your loved one can be traumatic, probably, his eyes being black and stuff like that. But just so, in case you didn't know, because when you think of somebody getting hit by a car, you probably, have an idea of what that looks like. But unfortunately, this was not the case here. And a reason why they couldn't say that he was hit by a car. So, hi, Amos. I assume you're home and well. Hope you're doing, babe. But he's stressing like these injuries, and it's like, okay, but also injuries look like, he was in a fight and got bit by a dog. So, okay.
at the scene of the accident, because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for.
You guys, there's going to be a quiz. There's going to be a quiz, so I hope you keep marking.
Are you writing this down? Where, when, how?
Yeah.
Rule 26. Drink.
12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased.
Can you imagine just sitting there listening to all these people speak about you and the definitive that you did this, even though you I would be seething.
Yeah. Yeah. It's super not fun to be in that position. Super
Yeah.
not fun to
Oh,
sit
my
there and
bad.
somebody say all these
With
things without facts actually backing them up and all that. Yeah.
like
I mean,
speaking as
I'll just
if
say
you did this, and you're sitting there going,
mhm,
"That is not
it's
how that
actually not
happened at
that how
all." Yeah,
sound off, queen, I
mute.
guess.
I'm gonna mute myself now. Whoops.
But I am curious though. I mean, so it does seem like they're going at this time of the case, right? It seems like they are going to go with the affirmative defense, basically her same defense as the criminal trial. Does that mean they're going to be bringing in all of the same witnesses? Because they're going to have to prove once again that this was not done by a car. Like,
Right.
are we gonna get
It's
our favorite guys? What were they from? Uh,
the
no,
FBI.
the FBI guys. They weren't
Yes,
from the
what I said.
FBI,
The
but they're
FBI
the
guy.
company hired by the FBI.
Aperture? No,
No,
not Aperture, but
it starts with an A. We like
I can't
them.
remember.
We like them. They
Crash
were the
Daddies is all
accident.
I remember.
Yeah, they were the accident reconstruction guys. Are we gonna get them again? Because you
It
know,
sounds like it's gonna be the
I
the
almost
criminal
see.
trial again, but in
Yeah,
civil court. It's what it sounds like, right?
yeah, they're gonna have to. Which again, I can't believe. I know the burden of
Which is
proof is much lower,
probably
but
why they brought Jackson back for
oh, I mean,
this.
yeah, they probably bought him and brought
Because
him and the others because they know it inside and out.
right.
Um,
I mean, I can imagine because that's what they're like, all right, we're gonna have to do like the criminal trial 3.0 in civil court. We're gonna
in
need
this
you guys
one,
because y'all know all the things.
they're
But
gonna have to do
Karen
it
knows too.
again with the federal, case of her versus, everybody else. They got to do it again with Canton, Massachusetts. Though I feel like they'll probably try to settle the MSP can't because the first document filed is
Well,
not good for them. But we'll see because these people are beyond stubborn, prideful. Prideful is the word I'm looking for. Uh, ooh, who knows? Aperture was one of the companies. I can't remember if they are the blue paint one. Aperture is the blue
yeah.
paint one with Shannon and Dr. Welcher.
But I
The
can't
other
for
one
the
starts with
life of me remember the Crash Daddies
I can't either.
company. I
I
don't
feel
think
like
it
it starts with an
matters.
A.
You know who I'm
Axiom?
talking to?
Axiom, is that their name? No.
No.
It'll pop up after
Um,
we're done with this show, I'm sure.
yeah, exactly. It's like, oh yeah, that's it.
That's right. That's right. All right, who's calling me? Was anybody calling me? Oh, hold on, let me put this back. But yeah, they're definitely gonna have to basically do the same case over again, maybe even additional things. I don't know. Okay, nobody called me. Cool. All right, but we are close to being done with this, not too terribly far.
His body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relation.
Arca.
ARCA! There we go. We were right with the A. ARCA starts with A, like orca.
Sorry,
Orca
I could not move on until I answered
I
that
get
question
it.
in my head. Sorry.
I get it. Oh, yeah, they're gonna have ARCA back again. And for those of you that don't know the trial, a certain alphabet agency had to step in, and it's a whole part of the story overall. The alphabet agency being the FBI for misconduct and whatnot. So anyway, there was a third party investigation by the FBI before was it in between the two trials that it happened, or it was before the first trial,
No,
right?
there
Because
it
they
was
were in the
before
first
the
trial.
first trial.
Yeah,
Yeah.
I thought so. Because they had to do their own independent investigation into all of this. Because there's a lot of shenanigans going on here. A lot.
relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness,
Stop. If it's all those thing, a blind person would ever win. I mean, I get it, but that's just a little bit too, like, literal, but okay. Okay, sir. Oh, Massachusetts, how I've missed you and your quirkiness. I appreciate it.
it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenk, 1979 case we cited to, Your Honor.
Boyle versus Wenk, that's a very funny.
Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened.
What was she supposed to do? What would happen?
Compound that.
What would your argument have been if she would have brought her with her? Like your argument would have been way
And
worse.
that's what I was just thinking. And she knowingly brought her to find his body in the snow.
Right? Like, what? I don't understand. What was supposed to happen at this moment? What, leave her sleeping while she again leaves? She doesn't know how long she's going to be gone. She doesn't even know what's going on. So the kids can wake up and nobody be home and wondering where they are. I mean, what? Oh, I don't know. I just feel like when we bring in the reasonable person here, and what a reasonable person would do, we're not.
There was nothing she could have done right in this situation that they wouldn't have twisted to make her the
Absolutely. And no, she should not have brought her with her. Like, that's way worse. That is inappropriate. I don't see anything really inappropriate about this because it happens, but I also don't think she was taking all of these factors in consideration either when she awoke her. But yeah, that really, what did you want her to do? I don't understand.
by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, or to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now
So that was
out
Turtle
fair
Boy.
game?
So it was Turtle Boy that said that, not,
Yeah.
or it was not specific in the.
I didn't think that.
It was
That
confusing
did
in that
not
paragraph.
sound like something that Karen Reed would say, but I didn't want to say anything until I knew for sure, because I don't like to misspeak, but it didn't sound like it. But I could totally hear Turtle Boy saying that.
Yeah, I think it was worded very strangely in the doc. I wasn't even sure who it was equated to, but all right. So now we know that it was Turtle Boy, that he's quoting him saying that. Even then, he's just quoting with things out of context. So I don't know.
I was about to say,
I have no idea.
The entire context of the clip, I assume they must have taken it from a video or something.
Oh yeah, I mean there was 32 pages about it, but I know it's going to come up again, so we're not going to cover it quite yet in this story.
No.
So.
Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game.
I can't wait to see all their proof that this happened, because those are some very big accusations. I can't wait to see what the plaintiffs have proving that she was this mastermind that, but okay. All right. Fine. Interesting.
Will track how much leaked information defendant should have known would result in distress to the O'Keefe family.
Yes, they do.
To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more.
I thought she didn't go on Turtle Boy.
This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you.
Okay.
Any response from the defense?
Your Honor, briefly, firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue?
Where's our little
All right, thank you. Certainly, there's a lot to the...
just because we can. Where is our Alessi one? Oh, there it is.
What could be more egregious? What could be more misleading?
That's right. We miss you, Alessi. We miss you. I mean, the reason people are so interested in this is because of the outrageous conduct done by other people, just by the way. Like, truly outrageous and shocking to the majority of people who watched these trials. But okay.
And again, for the record, so that people understand this is a pre-discovery form of relief that the defense sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation
because both sides going to appeal, whatever it is.
this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so.
Yeah, no.
I mean, literally, I've talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going.
Happen, by the way.
Your clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we can do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but
it's okay.
I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment.
And I think, can the bars settle if they want to and then be removed as defendants, but Karen can still go on? I would think so.
Yeah, I would think so. They're
Okay.
individually.
Mhm.
I would think that they could. I mean, this could really like put the bars out of business. I assume that they're small businesses.
Yeah. Yeah.
What that will mean in terms of ability to put this matter behind and going forward, it's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
He's like, we can do it spring, guys.
Defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here at Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days
Okay.
do you want to go?
So they're just scheduling
Yeah,
things.
probably 60
I
days.
think that's it.
20.
Yeah.
21st?
These don't actually matter.
Okay, I'll have a decision out before then, certainly, as quickly as I can. Discovery and bring in third parties.
Okay, that's all. All right. So that is the first large hearing of all of the parties here that is televised anyway for us to see. Now, the last thing I want to go over before we're done for today is the judge's order. What did he decide after this? So that way we're not, just being like, what did he have to say about it? So he puts an order in on October 3rd, 2025. So just a few weeks after this hearing, which seems to be the case in civil cases, as they take forever to put out orders, but okay. So the judge ends up rejecting most of the defendant's arguments, ruling that emotional distress is a separate harm from the loss caused by a wrongful death. Now, he also goes and makes a decision on the negligent emotional distress claims. He allowed the claims made by the family. They can move forward. The judge ruled they arrived at the hospital promptly after learning of his death, which fits the legal requirement, whether we like it or not, apparently. But he dismissed the claim made by Kaylee was thrown out for the negligent emotional distress because the judge ruled that because she only heard speculation that John might be hurt early in the morning rather than actually seeing him injured or encountering his body immediately after that event, it did not meet the strict legal definition for this specific charge. And then for the decision on the reckless and intentional emotional distress charges, the judge ruled that the claims, not charges, claims, sorry, forget which court we're in. The judge ruled that the claims of reckless emotional distress for the whole family can move forward. So for everybody, The judge stated that the pervasive public nature of the alleged media campaign went beyond normal disputes and are severe enough to let a jury decide. And then regarding Kaylee's claims on this matter, the judge refused to throw it out on this one. So on one, for Kaylee, it's been thrown out, but on the other, he's went ahead and let it go. He also said that the Bars and Karen Reed failed to get the overall lawsuit and their respective counts thrown out. So, and that is what is decided at this point in the timeline at the beginning of October 2025.
Okay, so the only thing the defense won is Kaylee?
Yeah. One of the charges, the or claims, I'm
Claims.
sorry, the negligent emotional distress was out the window, but the reckless and intentional emotional distress is still on the table at this point. So
Okay.
it's a semi win, but still there, kind of. Certainly interesting. Again, though, as the judge did say like 100 times over, with civil cases, this is just a ruling for the very beginning. Now, if they start not producing stuff to back it up, then yeah, maybe it could get thrown out. But I don't know. It's weird. Civil suits are so weird. But so I've already started putting together the rest of 2025 and 2026 where we are now. And we will get back to this very, very soon before the hearing next Thursday. I'm hoping to squeeze it all in, or Thursday we might finish catching up and then watch the hearing from the morning at the end of the stream or something along those lines. But we are actually almost fairly ish caught up. We've already made it through, a whole year of this. And again, I guess the trial is supposed to meet next year. So we'll see.
We're fairly-ish caught up. Is that there's a lot of hearings.
Yeah, but not a lot of them are very long. Not as long as you think they would be. They're usually like 20, 30 minutes, and that's it.
Yeah, but there's a lot happening in that 20, 30 minutes.
Right. Right. I got to lay it all out. That's what I'm doing. I still got today and a few other days to try to lay it all out and squeeze it all in there the best we can. But I mean, if we end up having to watch Thursday's hearing and then continue on, we'll do what we have to do. But for the most part, at least for 2025, I mean, it's a lot of back and forths about the same thing that like they're going to argue this entire time. So I'm just trying to condense things as much as possible because what you have to look forward to with the next batch of information is all of the subpoenas they handed out to the witnesses, including, the Higgins, Alberts, McCabe's, and the Proctors of it all, and how nobody wants to do a deposition at all. Is what the next bout of arguing is about. So, and is argued for a lot of part. But anyway, so I'm going to do my best laying everything out for you guys to get us all caught up here so we can kind of be more on it because things are moving very quickly, let alone there's 3 more lawsuits that are also moving, some a little bit quicker, but some are new. And all of that. Now, tonight I'll be on True Crime and Wine Time for part 4 of the Sarah Hartsfeld story. Very excited about that. That's a very crazy story if you've never heard of it. That woman is wild. And then tomorrow we're going to be back on both channels for more Laura Owens coverage. And then in the afternoon on the True Crime and Wine Time show, we're over there. We're going to be talking about some of the actual documents behind Netflix's new documentary, A Toxic Love Story, and talk about stuff that wasn't included in the documentary. So that's what we got for the rest of this week for you guys. Next week, I can tell you already, I am not going to be on anything on Monday because I'm going to go get my hair cut. And all of this is going to be it's going to be gone. It's going to be very, very short. Because that's usually what I do. I cut it once and then grow it out for years. So no matter what, there won't be anything on live anyway on Couch Court. So that's all we got today for you, friends. Again, I know it's very confusing. But we're going to do our best to try to organize it all and relate it all in a way that anybody can understand. So hopefully we did that. If you have not watched True Criminal Trials and you need something to watch this weekend, I'm telling you, or you need a refresher, go find those trials. You can find our coverage of it when I'm a little itty bitty baby over on the True Crime and Wine Time channel, as well as Buffy's on there, and Annie and some of my other Terry, some other friends are all on there. Or you can watch it without commentary on the trial channel, though I must say my in real time commentary is kind of like you're probably going to be able to relate. You're going to be able to relate to all the shenanigans. Because oh my God, it's so unbelievable. And I can't believe that they're still like going with this story. It's wild to me, but you know. Well, thank you. Thank you. We are the best. I'm excited for my new hair too. I have so much hair and I'm over it. But anyway, friends, that is all we have for you today. Please, again, make sure you like this, subscribe to this new channel because a lot of the new stuff we're covering is only going to be on Couch Court with Llama channel, not also on True Crime and Wine Time. So make sure you subscribe, hit the notification bell so you don't miss when we go live or drop an episode of things. And anything else you want to say, Buff, before we go for the day? Happy to be
No.
in it in the Karen Reed of it all.
I'm ready. Yes, I'm ready. I'm
Ready
ready
for
to get
some
back to it.
unbelievably wild, outrageous shenanigans. There is no better way to phrase that. But all right, friends. Well, until next time, as I always say, go forth and be amazing. All right. Bye, friends.